Clause number 25, DCCR 0297. You're charged with a state jail felony offense.
All right, the hearing begins. And pay attention because the judge immediately zeroes in on the dates. That quick glance tells you everything. When even the official paperwork can't keep the calendar straight, it's a sign that this entire proceeding is about to take a sharp turn. Details like these may seem small, but in court, they can unravel the whole timeline. And the moment the judge spots an inconsistency, you can practically feel the room brace for what's coming next. This isn't just a simple clerical slip. It's the first hint that the hearing might get complicated fast.
It's a theft of property from from August 24th of 2024, continuing through September 4th of 2020. That's not right. 23. We can't go. I think the dates are...
Yeah, it does appear to be off, Judge. I apologize. Let's see.
I mean, do you want to just pick one? I don't think it...
It should read August the 24th of 2023 through...
Okay. September 4th.
And just like that, the first major twist lands. A date mistake in an indictment might look minor on paper, but legally, it's a major red flag. When the timeline doesn't line up, the entire accusation can begin to unravel right there at the table. Everyone in the room knows what's at stake. The defense sees an opening, the judge recognizes the risk, and the courtroom tension spikes as each side tries to keep their composure. One small error has the power to shift the entire trajectory of the case.
Make a trial or a motion to amend the indictment, Judge.
Any objection to that?
What would the new date
Change the first year to 2023.
And they would both be in 2023, yes, ma'am.
Correct. All right, let me, hold on a second. Let me get that pulled up. Okay, so let me make that.
Take a moment. This is one of those scenes where the entire room seems to inhale at the same time. Whenever a judge pauses this long, you can almost feel the pressure settle over the courtroom. It's the kind of silence that makes everyone wonder what's coming next. Moments like this decide everything. This is where a defendant either stays firm on their explanation or things begin to slip apart piece by piece. All eyes shift toward the bench, waiting to see which direction the judge is leaning. The next few words could shape the rest of the hearing.
Charged with is theft from August 24th of 2023, continuing through September 4th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have, in that case here on the tablet, some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And it looks like there is no agreement in this case. Is that correct?
That's correct.
That's correct.
And so you're leaving your punishment in this case up to the court. You do have some rights to appeal. I want to make sure you understand, y'all signed the post-conviction waivers. Do you want me to mark through those?
Please.
Please, Judge. Thank you.
I want to make sure you understand you have an absolute right to have a jury come in and determine two things. The first is if you're guilty or not, and then you could leave punishment up to that jury if they find you guilty. If we go forward this way, you're leaving your punishment up to me. Is that what you want to do? Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
That moment right there carries serious weight. In criminal court, few warnings are as significant as this one. When a judge brings up potential immigration effects, it's not a routine comment. It's a life-shaping caution. These consequences aren't small print on a form. They can reshape someone's entire future. That's why judges deliver this reminder with a steady, deliberate tone. One decision, one plea, could determine whether a person remains in the country or faces an entirely different path ahead. It's a reality that settles over the courtroom with unmistakable gravity.
Contenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Leonard's not competent?
There you go.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. On that indictment, I did make a modification, like it's not at the top. I did a strike through and it's in the body. So see if it works right. I'm not sure if it's showing up well, but okay. And then we have cause numbers 19-33340 and 20-36095. And will your client waive the formal reading of those motions?
She will, Your Honor.
In each of these cases, I have motions to revoke your community supervision. It looks like both of them, well, in cause number 33340, you were placed on probation April 7th of 2021 for the offense of theft of property, a state jail felony. That was
This is the point where everything starts connecting. You've got multiple probation cases, fresh charges piling in, and a list of alleged violations stacking up like an unstable tower. And then there's count 1, the standout issue. Another theft accusation, landing right on top of existing probation terms. Judges rarely take this lightly. A new offense while already under supervision sends a message the court does not ignore. The mood in the room shifts instantly, and everyone knows the stakes just climb to a whole new level.
Your sentence that was probated for 5 years, is that correct? And then in that 36095 case, you were also placed on probation April 7th of 2021, and this one for theft of service, a state jail felony. That was also a 2-year sentence that was probated for 5 years. Is that correct? Each of these allege you violated your probation. Count 1 alleges that you committed that new offense of theft August 24th of 2023, the case that we just went through. Is that true or not true? Count 2 in each case alleges that you did not provide verification of performing the community service hours as required. And is that true or not true? And then count 3 in each case alleges that you were behind in your court-assessed fees and probably restitution in each of those cases. And is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 in each of these cases freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily in each case. Find sufficient evidence in each case to revoke your probation. However, I'm going to reset your cases and get the probation department to do an updated report. Again, that'll give me more information about you, your probations, what's going on, and then we will come back later for sentencing. And these are unagreed, correct?
That's correct.
Anything that you think is important for me to know, make sure you get that information to Mr. Rojas. He will present it to me on the next court case on your behalf. All right, do you need her? Okay, if you'll stop and talk to probation on your way out of the courtroom, please.